Hello everybody, my name is Jake Harshbarger and my presentation is on the Wright brothers suit for patent infringement. The basic patent covering the Wright's control system was applied for after the successful 1902 glider experiments at Kitty Hawk. Absent the drafting skills of a patent attorney, this application was rejected fairly rapidly. The patent was filed on March 23, 1903, and it covered only the glider control system. The patent examiner had rejected their invention as being inoperative. The patent examiner dismissed the twisted bicycle tire box exhibit concerning wing warping as being of no assistance. This was when the brothers decided to get professional help. They hired Harry Toolman. He amended the original patent application. This amendment permitted the Wrights to include the powered airplane as well as the 1902 glider. By May 1905, the examiner conceded that the amended application had disclosed patentable matter, even though he again rejected it. A further amendment in December of 1905 resulted in the examiner holding that the application applied to a powered flying aircraft rather than a glider. Toolman had argued the invention applied to both types of aircraft. Ultimately, the Wright brothers' 1906 U.S. patent was held to cover a pioneering invention, and as such was broadly interpreted to include gliders as well as powered airplanes. The patent also covered a combination of wing warping and a movable vertical rudder. It was also interpreted to cover an alternative control system based upon rigid wings and freely operating between the wing ailerons. Upon receiving their basic U.S. patent in 1906, the Wright brothers seemed to have hesitated in making American financial connections that would have facilitated putting their invention into marketable production. In 1908, the Aero Club of America launched an unsuccessful funding drive to purchase U.S. rights to the Wright patent and to place the invention in public domain. Wilbur Wright indicated that they would be willing to release their patent rights if a sum of $1,000 were secured by this funding initiative. Within 6 months of this, only $11,000 had been collected, and the effort was abandoned. For the Wrights, the situation was very disheartening. That was because they compared it to the German Public Fund, a fund that raised millions of dollars for the Zeppelin construction. Defending their rights in U.S. courts. In July 1908, Orville Wright had wrote to Curtiss concerning a newer model aircraft, the Junebug. This was after noting the adjustable wingtips. He offered to negotiate license terms under the Wright's U.S. patent. Curtiss had advised them that he did not expect to use the plane for commercial purposes, so the Wrights did not raise any objections. But when the Junebug was used for compensated exhibition flying, they renewed their demand. It was Curtiss's success in prize competition during the summer of 1909 which triggered the Wrights' first patent action filed against the Herring Curtiss Company. Litigation began in late 1909 when the Wrights asked the courts to issue a preliminary injunction against the Herring Curtiss Company. This would prevent the Herring Curtiss Company from manufacturing any airplanes until patent rights were determined. On January 3, 1910, the United States District Judge John R. Hazel issued a preliminary injunction and wrote a strong opinion upholding the Wright patent. 4 months later, the Circuit Court of Appeals reversed Judge Hazel's decision and dissolved the injunction on a procedural technicality. However, the essential basis for Judge Hazel's district court decision was that the Wright brothers had discovered a method for controlling lateral roll. This gave the Wrights a broad and liberal interpretation of their claims. Within 3 years, broad construction of the Wright patent was applied, once more when the further proceedings took place in the Wright Company versus the Herring Curtis Company. Again, Judge Hazel's opinion was in favor of the Wrights and most encouraging to their chance for success. Since the Curtis airplanes used a separately controlled vertical rudder, there was considerable legal argument over the originality of their modification of the Wright vertical rudder, which was linked to the wing warping controls. In this instance, Judge Hazel held that the vertical rudder was an essential part of the Wright invention, which, when connected with the wing warping system, secured lateral stability in flight. However, in the Wright airplane, the use of flexible wings, which permitted the wing angle of attack to be altered or warped, was also an essential part of their machine. It did not matter that the Herring Curtis wings were rigid and another method was utilized to alter the angle of incidence. Applying the doctrine of equivalence broadly, Judge Hazel stated, "The employment in a changed form of the warping feature or its equivalent by another, even though better effects or results are obtained, does not avoid infringement." Turning to the vertical rudder, Judge Hazel found it a valid subcombination within the overall Wright scheme for obtaining stability in flight, although it was not directly connected to the movable ailerons of the Curtis airplane. The vertical rudder was shown by testimony to have at least occasional use in countering aerodynamic forces generated by changing the angle of incidence of one wing surface. Testimony concerning the use of the Wright and Curtis vertical rudder was provided by both Army and Navy aviators, including pilots like Thomas Milling, who had flown both types of airplanes. In his 1913 opinion, Judge Hazel again held the Wrights to be pioneer inventors in the airplane art. He observed that the Wrights' concept was practical and their combination of old and new elements meritoriously advanced the operatives of airplanes of this type, from which astonishing flights have resulted. With an eye toward the confused legal definition of pioneer inventor, he then commented, "Even if the patentees were not strictly pioneers, they definitely surpassed their predecessors and are entitled to a liberal construction of their claims in controversy." In pursuing a vigorous prosecution approach to their U.S. patent rights, the Wrights virtually isolated American aviation from knowledge of rapid European improvement of airplane design and manufacture. Harry Tolman and the Wright Company came to the conclusion that they should sue the producers and promoters of the exhibitions and contests rather than attempt to locate and serve the foreign pilots. It was a practical solution, but a disastrous decision for public relations and economic well-being. In attacking the American sponsors of the contest, as well as those providing assistance to foreign aviators, the Wrights alienated those members of the business community who were most enthusiastic about flying. Conclusion: as matter turned out, the Wright Company would soon need all the financial support it could get, and the loss of the friendship of American promoters in the effort to curtail exhibition flying was counterproductive in the long run. The Wrights then recognized that bringing a small number of suits would encourage many would-be infringers to avoid litigation and obtain licenses before staging their exhibition. As a consequence, the aviation world was kept guessing. American spectators were deprived of their entertainment, and the engineering progress was severely restricted. Among all this, Wilbur Wright had devoted himself to these patent suits. He was then said to have died due to typhoid fever because he worked himself to death fighting these patent infringement suits. Thank you for your time.